We are back on Morning Line. Thanks for joining us. Our guest, District Attorney Glenn Funk here in Davidson County. It's very good to have him on this morning, talking as we went to the break on the Safe Surrender program. Hey, if you have an outstanding warrant, there was an opportunity for you in December to turn yourself in and they would work it out. And as we were talking to the break, I was wondering, maybe one reason some people didn't show up is they wondered, is this legit? Is this real? We've seen in other municipalities sometimes where sheriff's departments or such put out ads saying, hey, and they send out to the addresses, you might have won Super Bowl tickets. And now, hey, with the Titans doing so well, you could do the same thing, and then they show up and they say, no, just kidding, and they take them into custody. This was never a bait and switch.
No, never. We did not say this was for Super Bowl tickets.
Or anything,
What we said was, this is about if you have a warrant, you can turn yourself in. And what we saw is the overwhelming number of folks either had their case dismissed or were just given a new court date, and the outstanding warrant was lifted. There were a handful of cases where someone turned themselves in and it turns out their warrant was actually from a different county. My office contacted the district attorney in that county, maybe even the sheriff's department in that county. We got 2 or 3 of those still dismissed, even though they were from out of county. We didn't even know if we would be able to do that, but we were successful. There were a couple folks that turned themselves in on more serious offenses, so it was done safely, but it was an outstanding warrant for a violent felony. We had tons of great stories because anytime someone's case was dismissed, as they would walk back out through the people that were waiting, just spontaneous applause would come for that person who was
awesome.
Then heading out the door, celebrating freedom without having the cloud over their head, without having to look over their shoulder. There was a woman that came in and she had not been back to Tennessee in 3 years, had not seen her kids in 3 years, and the kids were grown, right? It wasn't like 2-year-old, 3-year-old. Hadn't seen her kids in 3 years because she was afraid to come back because she had these warrants. But they were all for very minor offenses that were now, 3, 4, 5 years old. And when those charges got dismissed, she was heading out the door to the best Christmas ever.
I just think that's awesome. And so we know why it's important to people like that. Yeah, just tangibly speaking, for others who don't have warrants, but they see you doing this. This is good because it clears the books. It lessens the burden as opposed to having 33,000 outstanding warrants. I mean, how does this tangibly help your office, the sheriff, and maybe the taxpayers?
Right. All right. Well, I want the resources of my office to be dedicated to violent crime.
Okay.
Right. I want to be dealing with the rapes and the murders and the aggravated robberies. Right. I don't want to be chasing folks for cases and having those cases then clutter up dockets and having our jails filled with people who are ultimately going to have their charges dismissed or worked out on a time served or a fine and cost, as opposed to somebody who needs to be incarcerated. Not only that, it's important for the community to trust the criminal justice system. It's important for members of the community to feel like they're part of the community. If you've got an outstanding warrant, you do not feel connected to your community, right? You feel like it's kind of an us against them. You feel like you're being oppressed. Let's all work together to try to make sure that issues are addressed, but at the same time, let's make sure we try to have a criminal justice system that does not divide our community, but instead brings our community together.
Gotcha. All right, let's we could take a phone call or two. We've got Linda. Linda, good morning. Hi, Linda.
Good morning, fellas.
Good morning.
Got a couple of things. Number one, since the Safe Surrender program has been so successful in the little time that it's been used, could they consider doing this a couple of times a year and get some of these warrants out of the way? And secondly, what are the chances of a person who is on the sex offender registry for molesting a child, being his sentence or whatever being expunged? He has been out of prison now quite some time, but is on the sex offender registry. We're just kind of concerned that there could be a chance of him getting out or getting this taken off of the sex offender registry.
All right. 2 things. Number one, if it's a sex offense, then it cannot be expunged. So we do not have to worry about the sex offender having their record expunged or getting off of the registry. There are some sex offenses, statutory rape, things like that, that after you've completed your sentence and you get 10 years down the road, then you can come off the registry. But any major sex offender is on the registry for life. Second of all, with regards to safe surrender, we are for sure going to continue to do this at least once a year. And in the meantime, we're doing an audit of these outstanding warrants where we're working our way through all 33,000. And the ones that are obviously not going to go forward, we're going ahead and doing a dismissal, sending that to the judge that it's dismissed, and then we're going to send a letter to the address that the offender had at the time that they picked up the charge so that they know this is no longer outstanding. That will also take it out of the Sheriff's Department outstanding arrest warrants, and it will keep it out of the police department as far as having an outstanding warrant for those individuals.
Gotcha. Linda, thanks for your call. And can we just go back to expungements? And I understand your point on sex offenders. And again, that's the type of crime. It's almost in a category of its own, and
right.
You understand why that is. With regard to expungements, and there may be individuals out there with a range of crimes. If it's a violent crime, if it's an armed robbery or an assault, ag assault, things like that, you've been convicted. You know, you were an adult, but maybe it's been what are the chances of having something like that expunged in your mind? And how do you view that if someone maybe years later has turned it around? Does that continue to be a scarlet letter for the rest of their lives?
Right. Well, I believe in second chances, and I believe that many cases should be able to be expunged. There's already provision on the books that if it was an offense that was a misdemeanor or a D and an E or a D and E felony, most of those cases, after you've completed your sentence, 5 years later, you can get those expunged.
Okay.
Right. Many cases all the way up to C felonies can be expunged if at the time of the plea or at the time of the conviction, the judge determines, hey, this is the type of case where at the completion of your sentence, you can get it expunged. Murder cannot, right?
Right.
Rape cannot. Aggravated robbery, armed robbery cannot.
Okay.
So the more serious felonies,
that's
right.
That's with you.
That's with you. That's with you forever.
You mentioned judge. Do you play a role too, though, on some of these expungements? Are you there? Maybe telling the judge what you've seen, or I'm just wondering if someone does this, they apply, and what role do you play? The judge makes the call, I guess.
Right. There are times when we recommend to the judge that might be a case where at the completion of probation, the judge should be able to expunge the record. And so we do that sometimes. Sometimes we have a sentencing hearing where the judge makes that determination. And then the legislature's already made that determination that for a number of offenses, almost all misdemeanors, not all misdemeanors, but almost all misdemeanors, and some low-level felonies, those can be expunged after that 5-year waiting period.
Okay, but you also may be on the other side of the coin. If you saw someone up for it that you felt strongly should not get it, you could speak out against it.
For sure. There are some people who are eligible for the judge to make their conviction expungible, and there are times when we stand up and say this should not be expunged for this reason, or this reason, mainly public safety or protecting the victim going forward.
Okay, and we were talking there about adults and the scarlet letter and having to deal with a crime for the rest of your life. All right, that's where it brings us to the Juvenile Assessment Center. Youngsters, all right? Now, that's a different ballgame. We're dealing with kids. And some are committing adult crimes, and they've got to pay the piper. But on the other hand, this Juvenile Assessment Center, I want you to talk about how maybe, in your view, what this will do is prevent them from progressing to the point where they commit these types of crimes that basically ruin their lives and the lives of others.
Right. Right. Well, juvenile court, every criminal statute that applies to adults also applies to juveniles. But then there are other offenses, transgressions, that are in the juvenile code that would not be in a code for an adult, such as being a runaway. Okay. Right? If you are a runaway, if you're an underage youth in our community who runs away, police reports made, hey, my 15-year-old just ran away. I need some help trying to locate.
Now, is running away a crime?
Child. Yes.
If you're a juvie and you run away from home, is that a crime, or is that because it's truancy or something?
It's all legalese, but essentially it is. It
is a crime for a kid to run away from home.
But it's not something you can put a youth in jail for.
Okay.
You cannot detain that. And so when they're found, what happens is they're taken down to juvenile court, and it's a status offense. It's a status offense. So they're taken in front of a judge, they're given a probation officer, they're given a talking to, but without having any ability to detain, then they're just simply released. Well, that's a problem because the chances of you having gone to juvenile court, then doing a real crime that leads you back to juvenile court goes up exponentially.
Why do you think that is?
Well, I think it's because once you start thinking I've been taken to juvie, right? Once you start having to go in front of a judge, then you just kind of see that as normal, like this is what's going to happen to me. And you've already gone in front of a judge and received essentially no sanction. Right. So where's the deterrent effect in that?
Okay, we have to take a break. That's exactly what I was wondering if you're going to follow up with that, is that they went in, they faced it, and they walked out, and they're wondering, well, this may be the way it is no matter what I do. So let's talk more about that. We'll take more phone calls. It's a really interesting program. 737-7587. Anything that can kind of reduce the chances of them committing more serious crimes, because, boy, we see too many of these. They're caught with guns and carjacking. So we'll be back with more with District Attorney Glenn Funk right after this.